For the appellant, I assume you have already reserved your time for rebuttal?
Yes, Your Honor. I'd like to reserve 5 minutes, please, if I could. Good afternoon. I'm sorry about my voice. Good afternoon, and may it please the court. I'm Lynn Guerrero for the appellant. And like I said, 5 minutes for the rebuttal. This appeal arises mainly from 3 orders of the trial court: 1 holding appellant in civil contempt, 1 declaring the appellant an abusive civil action litigant, and an interlocutory order disqualifying appellant's chosen counsel. Appellant was held in civil contempt related to proceedings on execution of judgments for failing to tell the appellee where his monies and holdings are. However, he repeatedly told the appellee and the trial court where all his holdings are, and these holdings are in excess of the judgments at issue. The holdings, as this court knows, the holdings are in a trust, and the appellee could attempt to execute on that trust, but she's never attempted to do so. Instead of trying to execute, the appellee sought to have the appellant held in civil contempt and incarcerated for not telling where his holdings are, even though he repeatedly did so. On March 1st, 2020, I'll just go through the timeline here a little bit. On March 1st, 2020, the appellant responded to written discovery. Later that month, in 2020, the appellee, without having filed a motion to compel or identifying which of appellant's responses were allegedly deficient or what objections, were raised that maybe were wrong, the appellee instead filed a motion for sanctions, alleging that appellant's responses were not complete. Appellee's motion for sanctions, though, did not respond to any of appellant's objections. It was just a couple-page motion. I think it was like 2 pages that said that was vague and non-specific. It just wanted sanctions because the appellant didn't respond the way, I suppose, the way that appellee wanted the appellant to respond. Nevertheless, the court found that the appellant did not respond to the discovery in good faith, and that's quoted, in good faith, and ordered the appellant to supplement his responses by October the 15th of 2020, in good faith. And an appellant did so. Then next, in November of 2020, without ever having told the appellant which of his discovery responses the trial court deemed deficient, the court held appellant in civil contempt and ordered him again to supplement his responses in good faith. During that hearing in November of 2020, the appellant asked the court for more specificity, for more clarification. Okay, well, what do you want me to do? What can I do to make these sufficient for the trial court? The trial court, however, told the appellant that he was a, quote, smart fella and could, quote, figure out what the court meant by good faith, and refused to give the appellant any further detail despite the appellant's requests for clarification. The appellant then, in January of 2021, filed a motion for a ruling that he had satisfied his discovery obligation for clarification and for an opportunity to cure any claimed deficiencies in his responses. Appellant in the motion, that's part of the record, that's a January 4th, 2021 motion, states that he would do anything in his power that the court instructed regarding any supplemental responses. The appellant asked to be told, particularly after his supplemented responses, what specifically was not answered correctly or sufficiently, or what objections were improper, and he would comply with an order as best that he could. Now moving forward, the court on May the 17th of 2021, the court held the appellant in civil contempt yet again, and without ever having ruled on the January 4th, 2021 motion about clarification and more specificity in the court's good faith order, held the appellant in civil contempt again, ordering his incarceration for his, allegedly deficient discovery responses, ordered that he turn in his license and U.S. passport to quote-unquote appropriate authorities without having any authority to do so, or no testimony, no proof, no nothing to do that, without ever having adjudicated a single one of the appellant's requests, requests for clarification, never adjudicating a single one of the appellant's objections, claims of privilege, claims of work product, things like that, nothing. Never adjudicated a single one, however, ordered him to be incarcerated for deficient discovery responses on an order of good faith. Now, this court knows that in a similar situation in Godsey versus Godsey, this court cited Convalinka versus Chattanooga-Hamilton County Hospital Authority. The order giving rise to an order for civil contempt, a holding of civil contempt, that is, must be clear, specific, and unambiguous. Well, here, the court held the appellant in civil contempt for lacking good faith in responding to discovery requests. This is precisely the type of reasoning this court condemns in Godsey and in Convalinka, as the trial court's, quote, good faith requirement is something that is not inherently clear, specific, or without ambiguity. Orders giving rise to civil contempt must leave no reasonable basis for doubt regarding their meaning. This court notes that there's an objective standard for assessing ambiguity, and all reasonable inferences must be in favor of the person facing contempt. Here, the court stated the order was not ambiguous, because the trial court, that is, because the court claimed it believed it was clear to the appellant, because the trial court believes that the appellant is, quote, smart. That's not the standard. That's not an objective standard. The trial court below also failed to find any willfulness in the civil contempt holding. To sustain civil contempt, one must be found to have willfully violated a court order. Here, specifically in a writing to the court, filed with the court, the appellant offered to do anything in his power to do what the court specifically ordered him to do. He asked the court to tell him which discovery responses were insufficient or which objections were improperly maintained, and he would reform them. To this day, has never gotten an order on that motion, has never gotten a ruling, has never gotten any ruling on any single objection or claim of privilege or what have you to his discovery request. Yet he is still, almost 2 years later, still has an order out there for his incarceration for civil contempt. Also, I do want to point out that in December, there's no purge analysis done whatsoever. The appellant moved to purge the civil contempt at least once in August of 2021, and maybe again. There's no purge analysis done by the trial court whatsoever. As this court knows, in civil contempt, the person held in contempt may purge that at any time. And no analysis by the trial court has ever been done on this issue. Further, on December 29th, 2021, the appellee sent correspondence to the appellant for permission to speak with individuals in charge of the appellant's funds in aid of execution. The appellant agreed to give the appellee written authorization, to contact the trustee, and provided the trustee's name, address, and phone number. Again, in return, the appellant provided a proposed order to the appellee relieving him of contempt, and informed his execution of the written authorization to speak with his trustee was contingent upon the party's execution of an agreed order dismissing the civil contempt. Appellant, my client, never received a response. That shows there's no willfulness in any civil contempt. He's helping appellee, he's aiding appellee in executing on her judgment But appellee's strategy, it seems here, Your Honors, is to incarcerate the appellant to pay the judgments, which is, as I'm sure you've read in my brief, that it's an unconstitutional debtor's prison. Even the appellee's counsel at hearing on May 17th, 2021, asked the trial court to put him in jail for not paying the judgments. That is an unconstitutional debtor's prison.
Yeah, let me ask you, all of this discovery in aid of execution of the judgment, is all of that in the same case filing as a petition for modification?
It is, Your Honor.
It's all in the same case? So
It's all in the
same docket number?
It is, Your Honor, yes, it is. And it looks like I'm out of time, so.
You have your rebuttal left.
Thank you.
Right ahead.
Aaron David Balloon, Knox County Bar. I represent the appellee, Ken Nelson. And one of the things I think is important to note, we filed with our brief appendages the interrogatories and answers that were given. So when they say they tried to answer in good faith, let's go with the first question. Please state your full name, address, and telephone number. Objection. This information has been produced and disclosed several times already in this case and has not changed. This interrogatory is clearly unnecessary, duplicative, and burdensome given the obvious plaintiff is aware of this information. That was the response. Second, please state your name, address, telephone number, your principal place of employment, your job. Objection. This information has been produced and disclosed several times. Defendant is a member of Loring Justice PLLC, but he doesn't give any information. At the time this was answered, I believe Mr. Justice was a disbarred lawyer. So I'm not sure what Loring Justice PLLC is. He didn't tell us. And then we asked if he was a member of any sole proprietorship. Question number 4, answer none. Then we go and we ask, please list all real property you have any interest in. Answer, objection to the very vague nature of the term interest. Now, these are the type of answers he's given. Then we go and ask for his car information. List all vehicles, rolling stock, and description. So we ask for the VIN number and things. And his response, the only vehicle is a rolling stock is the defendant has interest in a 1999 Saab 9-3. But he doesn't give any information. We ask about stocks and bonds. He responds, objection to the vague nature of the term interest. Defendant may be a benefit from an IRA, and IRAs are immune. Well, the problem is with that, under federal law, IRAs and things for child support and perhaps derivative child support and alimony, there may be an exception. But we received zero information. Then we asked for bank accounts. List all bank accounts. Objection. The term interest is vague and ambiguous. Then, which is kind of important, if you go over to page 10 of the appendix, part 3, produce copies of all brokerage account statements from January 1st of 2017 to the present. Objection. The term brokerage is not self-evident. These are the kind of answers that were given. Then he filed a supplemental response. If you look at the supplemental response, he doesn't go line by line, number by number. He goes introduction, and then he talks about a trust. But the important thing about the trust is he doesn't give us the account numbers. He talks about it. It's in Cayman Island, but he also, what she fails to say is, it's in a trust that he hid the money, over close to $1 million. My client had a judgment for $435,000, which was upheld by this court. This court not only did that, but in the appeal ordered attorney's fees, and attorney's fees of about $135,000, $160,000 was awarded and upheld by this court again. So we were trying almost $600,000 to $700,000 owed. He goes on and he says, now, here's the question. When she says about They offered to give us information. We dismissed the lawsuit. This is the problem with that. If you look at our appendage, Exhibit 1A, it's a statement of lawsuits. If you look at the statement of lawsuits in there, on page he has filed a lawsuit against me, Martha Mears, personally in circuit court in Knox County, and for hostage negotiation. He's saying because we represented Mrs. Nelson, this is all derivative. This is not a divorce. It is a paternity case. So he files a lawsuit against me, and when Judge Stevens was about to rule, he non-suits. And then what does he do? He then comes over to the federal court and files the exact same action of hostage negotiation. So when they say we didn't respond, that's the reason. The other thing that's important, if you look at the statement of the law or the lawsuits, he filed a petition 3 times to modify the parenting plan. Now, under 36.6.101, it says that it can be modified upon the exigencies of the case, but it also says that the court maintains sole jurisdiction. This is out of the juvenile court. What he did is he shows up to Roane County, and he files a modification petition and puts another docket number. So opposed to it going back to Judge Ash, who was the trial judge, it goes to Larry Warner out of Crossville. That was dismissed and upheld by this court. The dismissal became moot. As you all said, this was it was done by Rule 10. Then he files another lawsuit in the custody case, and that was in front of Walter Kurtz. We then asked for discovery there. We had it set for 2 days trials, and what does he do? The day before trial, he non-suits. Then and that lawsuit was petition to modify November 20th, 2017. The first one that he filed in front of Kurtz Warner. We've had 6 judges in this case, so some of them get a little confusing. He dismisses that. Then he goes and files a third one, and this is in front of Judge Acree. Now, what's important where she's talking about this purging himself, we filed a motion to compel, and that was the original document. And then he files his response. His first answers came in the first day of March 2020. That is our appendix number 3. He then files his next response, and you heard her talk about he was given so many days until October or so of 2020 to get them. We didn't get the supplemental response until May 14th, 2021, 14 months later. But if you look at his responses, he doesn't go through the original questions and come down through the questions and answer them. If you look on a parenting plan, it has, as part of a parenting plan, it says that you have to give proof of income and work-related child care expenses. Each parent shall send proof of income each year, including 1099s, W-10s, or W-2s, 1099s, and the tax. We never got them. Then he says, we're going to give you some documents. We show up at a place, no copier, they're just there. We can't take them. We can't take the documents. We don't have a copier made available to it. We can look at them. So therefore, when she talks in terms of this, it's important to note when she says about having a hearing, he didn't show up. He didn't show up at the hearings. We had a hearing set for him to address all these issues. He sent a court reporter. He had a court reporter there, but Ms. Guerrero was not there. Mr. Justice was not there. And then we proceeded to have a hearing, and we put on proof. We had a transcript of the hearing. So,
And is that in connection with the discovery that he didn't answer, that you had a hearing?
say it one more time.
What was this hearing about?
The opportunity for the contempt and everything in his motions, where she says we had filed motions and we didn't have an opportunity to be heard. They did.
So it's on his motion to compel that you had a hearing?
No, my motion's to compel.
Your motion to compel?
Yes, and he was there because he was held in contempt, and then when she said there was no purge opportunity, he could have easily came in, had a hearing, and said, here's what I've done, and showed up. Now, I think he probably didn't because he was, some people say thumbing his nose at the court or what have you, but he didn't. He had the opportunity. The question, in fact, what happened is when we were there, he was late. Well, I should say he never showed up, but I told the court, Mr. Justice has a propensity to be late. So the judge says, we'll wait 30 minutes. And we waited 30 minutes. So the court called out at 9 o'clock, Mr. Justice is not there. I then say to the court, Your Honor, he sometimes runs late coming from Knoxville. And the court says, well, I will give him the benefit, words to the effect, I don't want you to think I'm quoting the judge, but words to the effect, I'll give him the benefit of the doubt, we'll wait 30 minutes. No show. So the situation is, the other parts of their pleading, the child is aged out. We have a suit on the abusive civil action. The child is now aged out, turned 18 on February 7, 2023. So I think a lot of their petition is moot.
Was there a hearing on the pleading to have the court find this was an abusive civil action?
Yes.
And
Yes.
Is there a transcript in the
Yes.
record? There's a transcript in
Yes.
the record of that hearing?
Yes.
And who testified?
We did more, the statement of the lawsuits were presented, and my client was there, Ms. Nelson was there present. I can't remember, it's been a long time. I think I think what happened is the document was handed to her, and you identify this, yes. And if you read the statement of the lawsuits, it's condensed here. It has, but all the supporting documents were there with all the lawsuits. See, this gentleman sued.
Well, let me ask you, should we be looking at all of the lawsuits, or should we be looking at the petition to modify in 2017 versus the petition to modify in 2019 to see if those were similar?
Absolutely.
And are they similar?
Yes.
And why do you say that they are?
Because they're almost verbatim. And one of the things is he says he's now married. However, Ms. Guerrero, back in 2000, well, let's just say if he was 12 years ago, would be 2011. He was not married to her, but they were a couple, and she testified at the hearing. In fact, they introduced pictures in the hearing before Judge Ash of her, the child, and Mr. Justice in front of a cooler with a crab or something. So they had been in a long-term relationship. She was his law clerk, and now the wife, now the attorney. So there, all of that, I think that was there, and there may have been a statement that she, Ms. Guerrero, and Mr. Justice has a child. So all the other facts, if you look at them.
I'm still not clear on whether there was a hearing. You said there was someone presented a statement of the lawsuits.
I think Ms. Nelson testified. I don't want to be.
Is there going to be a transcript?
It's in the transcript.
Because the statute requires a hearing.
Yes, Your Honor.
And a hearing requires a witness who testifies under oath, not statements by counsel.
I understand.
Okay. So we're going to find in the record a hearing where someone testified.
I hope so. I believe so, but let me say, if you look at the statement of law, we have been to the Court of Appeals 3 or 4 times on this case. This is just a paternity case.
But see, we're just looking at 2017 and 2019.
I understand.
All those other cases
Right.
don't really matter to us. And
Well, I
the
hope
other
they-
thing I want to know, was there any relief granted him in connection with the 2019 petition?
No.
Because I understand from reading the briefs, there was an agreed order changing the amount of the child support.
That's correct.
All right, to the extent that there was
Other than that, that was because of the new child.
all right, well, if in fact, in that 2019 filing, there was an agreed order changing the amount of the child support, could you label that as an abusive lawsuit without merit in that he prevailed in part and got his child support
No,
reduced?
because there was 2 petitions. One was a petition to modify, and a separate petition to modify the co-parenting, and then a separate petition to modify the support.
But all of that was alleged in the one petition filed in 2019, as I understand it.
It may have, I'm just saying, I think there were 2 petitions, one to modify child support, and then one to modify the co-parenting time. And on the child support, it was modified because there was a new child, but all the numbers as to income is the same. Keep in mind, this gentleman from the age of 8, when the child was 8 and now 18, he has not had any overnight co-parenting time, 0. So on the parenting plan, you put 0 for visitation for him and $365 for mom.
Let me ask you one other thing. I know your time is up. Is all the discovery a part of our record on appeal? Because normally under the rules, the discovery doesn't come in, but this case is sort of about the discovery that was, that supposedly wasn't answered.
Correct.
How do we make a determination about that if we don't have the discovery?
It's there.
And in looking at the judge's orders, there's not a lot of specific findings other than not in good faith.
The discovery is there. It's an appendix to our brief and to Ms. Guerrero's brief, and it was filed with the court. So the petition, the discovery I was reading from is part of the record.
Not your brief. It's a part of the record.
I believe it is.
Not an appendix
Yeah,
to your
because we
brief.
filed them with the court to show the court how he was not being responsive. That's why the motions for sanctions were filed. It is part of the pleadings in the file.
Okay,
Okay.
thank you.
Thank you, Your Honor.
Yes, ma'am.
Thank you, Your Honors. To answer Your Honor's question, there was no legitimate hearing on the abusive civil action petition.
There was no hearing?
There was no legitimate hearing. There was a hearing held.
was it?
There was no testimony given. Nobody called any witnesses. Ms. Nelson sat, perhaps at council table, I'm not sure, and said a few things, but nobody was put under oath. No proof was put on through any witnesses. And further, as we know, the statute states that an evidentiary hearing must be held. However, Mr. Justice was precluded and prohibited by the trial court from doing any discovery whatsoever regarding his petition or regarding his response to the petition.
Counsel says this is all moot now, that the child is aged out. I don't know whether they've collected the judgment or not.
Sure, it's not, and here's why. Number one, the petition for modification that was filed in August of 2019 did include the child support, the request to modify the child support based on different circumstances in income and such. That's not moot. That is still in play. If he had a child support order over him for at least since 2019, likely since 2017, however, at least since 2019, that was much too high given his change in circumstances, the birth of his other son, that's still in play. Number two, they can't have it both ways. The abusive civil action order states that he's precluded from filing any lawsuit in any way against the appellee for 6 years. Now, if the child's aged out, that's fine, but the abusive civil action order that is on appeal here states that he's not allowed to file anything against the appellee for 6 years, and without the prior authorization of Judge Acree. Now, we know Judge Acree is retired. It doesn't say the Roane County Juvenile Court. It doesn't say whoever's sitting, on that, for that case or anything like that. It says specifically Judge William Acree.
Obviously, it would be whoever the successor judge is under the rules.
And then number 2 is this precludes Mr. Justice, even if, God forbid, I'm not saying that this would happen, but even if appellee committed an intentional tort, a battery or something against Mr. Justice, that he couldn't file something against the appellee for doing that. It can't be moot, but then still be enacted and restrict his rights. It can't be both ways. So in terms of the statute is also a bill of attainder and ex post facto law. Just really quick, the bill of attainder, she told the trial court, and has told the trial court several times, that she is the one that went to the legislature and got this passed because of this case. That is a bill of attainder. You cannot do that. It's unconstitutional. And it's an ex post facto law because this is being applied to cases that were ongoing, or a case that was ongoing since at least 2005. That's an ex post facto law. It's unconstitutional in both ways. Anyway, on the contempt issue, the appellee never filed a motion to compel after March 1st of 2020, after Mr. Justice responded to discovery. No motion to compel ever. The appellee never addressed good faith in her brief, never addressed good faith here, because it's so vague. An order giving rise to a civil contempt holding has to be clear and unambiguous. Good faith is like asking someone, perhaps who has, perhaps a Baptist and an Episcopalian, how they define Christianity. That's probably going to be different. And that's just subjective to each person.
Isn't it implicit, actually, in responding to discovery, that you're going to do that in good faith?
No, and here's why. Because, depending on the questions. Now, if you don't answer them at all, I suppose that would be bad faith or not good faith. So I suppose it could be a little bit of an implicit kind of requirement in answering. However, if you have genuine objections, if you have genuine claims of privilege, genuine claims of work product, and those are never discussed, never adjudicated, that cannot be held against you for lack of good faith.
Did your client answer every discovery request that he did not lodge an objection to?
Yes. And it looks like I'm out of time.
The record would speak for itself, though. Thank you very much to both parties for your presentation. Your case has now been submitted to this court for resolution. You should receive our order and opinion within a reasonable period of time. If there's nothing further, you may be excused.